Good afternoon. My name is David Freeze, and this is the BESA Webinar. And welcome to today's webinar, which is about Brexit, something you thought had long gone forgotten, but is back. But is it Brexit? Is it COVID? Or is it a combination of the two, Brovid? But first, a small internal announcement, and that is a welcome to Charlie Pierpoint, who's our new webinar producer. Charlie, are you there? Welcome, and you're on mute. That's a great start.
Thanks for the introductions, David.
Thank you, and welcome to the show, as they say. Where have you come from?
I've come from a company called Clarion Events, so I was working as an event manager for the last years. So really excited to be at these.
Good, and at some point you will get to meet some of us, but for now, thank you for, and we'll see you no doubt in the background in the future. Thanks.
Thank you.
Okay, so let's go on to our the main attraction today. I'd like to introduce David Rintoul, who's a partner at Hill Dickinson LLP. He's going to be joined later by Kevin McVeigh from Elliott, Duffy, Garrett Solicitors. I think Kevin's come up, and David, hi, welcome.
Hi.
Thank you.
No, David, you're in working from home in Reading. Is that correct?
Yes, that's right. Yes, indeed. And Kevin's working in his office in Belfast.
Okay, and but David, you joined Hill Dickinson in May and have yet to meet anybody. Is that correct, or hardly?
Yes, so that's pretty much correct. Yes, so can't wait to get back into the office.
Back in or into the office, full stop, wasn't it? And Kevin, you're in Belfast. Is that correct?
Yes, in the city centre, very quiet city centre at the moment.
Good. Look, I'm going to leave you guys to carry on with the presentation. I'll come back with Q&A at the end. If you have your questions, please let us know them now, and I'll be asking them at the end. Good luck.
Thank you, David, and thank you very much for that introduction, and good afternoon, everyone. Following the recently concluded Trade and Cooperation Agreement reached with the EU, which came into effect on the 1st of January, Kevin and I thought it important to examine what the trade deal means for the construction industry in Great Britain and Northern Ireland. Of course, there's a lot of uncertainty. Whilst the fact of the trade deal means we won't see the inflationary shock of tariff and quota introductions or the expected currency depreciation associated with a no deal. However, more than half, about 58% of UK firms say that border delays as a result of Brexit are longer now than at the beginning of January. And recent research published last week by the Chartered Institute of Procurement and Supply found that almost 2/3 of companies have experienced delays of at least 2 to 3 days getting goods into the UK from the EU, up from 38% in January. The situation is only slightly better for exports, with some 44% experiencing delays of 2 to 3 days getting goods into the EU. So whilst it's to be hoped that the deal will keep the costs of importing construction materials down and current border issues aside, at least provide some confidence over trading in goods, the Construction Products Association notes that whilst 24% of construction products used in the UK are imported, of these, 2/3 come from the European Union. It's therefore very important that we look at the potential impact of Brexit and the trade deal on the construction in the UK more generally. And Kevin and I, in this context, are going to be examining the new UK regulatory framework and harmonization of standards, mutual recognition of goods and product marking, and its application to the construction industry, the movement and cost of materials, and workforce shortages. If we can move to the next slide, please. If we can start then by looking at the new UK regulatory framework and harmonization of standards. The slide mentions the Construction Products Regulation, or CPR, And this is a piece of EU legislation that sets EU-wide standards for products used in construction projects. It provides harmonised rules or standards for the marketing of construction products. Standards define the methods and criteria for assessing the performance of a product in relation to its quote-unquote essential characteristics. And these products are marked with currently a CE mark to indicate compliance with the applicable standards for each product. On the 1st of January, the European Union Withdrawal Act came into force and converted the CPR into UK law so as to not leave a gap in the statute book. It also amended the UK Construction Product Regulations 2013, which provide for the enforcement of the CPR's requirements by trading standards authorities across the UK. And therefore, as of the 1st of January, all existing European harmonised standards became UK designated standards. The European harmonised standards and UK designated standards are identical. The government is intending to publish and maintain the list of UK designated standards, which will be a UK-wide approach, therefore, with the standards applying at UK level. Kevin, would you like to just introduce the Northern Ireland Protocol and related political declaration and how that impacts on the framework?
Yes, David, thanks. Essentially, as some of you will probably have heard in the news over the last few years, the reason behind the protocol was to avoid a hard border, as it's described, on the island of Ireland. And so essentially the EU was concerned that Northern Ireland could be used as a back door for goods to enter the EU from GB into Northern Ireland and then across the border into the Republic of Ireland, which is still a member state of the EU. So what the protocol essentially states is that there will be checks on goods travelling from GB to Northern Ireland. There will be no checks on goods travelling from Northern Ireland into GB, and because Northern Ireland under the protocol is still part of the EU single market for goods, there are no checks or tariffs on the transfer of goods from Northern Ireland into the EU, including the Republic of Ireland. So I'll talk a little bit more about how that is being administered as the presentation goes on.
Thank you, Kevin. And if Charlie, we can move to the next slide, please. So the intent of the amendments to the CPR is to adapt the current regime properly with the UK having left the EU, but without amending the CPR or the 2013 regulations any more than is absolutely necessary. And so therefore, the standards applying in the UK will remain closely aligned with EU standards, and at least initially will be exactly the same. The immediate key differences will be in how new products demonstrate conformity with the relevant standards. And so to that end, the standards applicable in the UK will continue to be closely aligned with EU standards. And as I say, under the amended regime, the EU's existing harmonised standards become UK designated standards. This means that construction products already placed on the UK market before the 1st of January this year will therefore remain compliant with the applicable UK standards, and so will still be able to circulate and be used. New UK standards will then come into force either by mandating a standardisation body to develop new standards or by adopting a standard already approved by the EU. It's therefore possible that UK and EU standards will diverge over time, although it should be noted that that isn't the current policy intention. It's the intention that they remain identical or very closely aligned. Moving on to the next slide. Kevin, if you could talk to the issues set out in this slide, please.
Yes. So as I've mentioned, there are a number of different scenarios. There's the movement of goods from Northern Ireland to Great Britain, and under the protocol and the declaration, that remains unchanged in terms of forms to be filled in or any other checks and controls. It's as you were. The real difference is on the movement of goods from Great Britain to Northern Ireland, for the reason that I gave. What the government has done is to set up a trader support service for businesses in Northern Ireland and Great Britain who are involved in the movement of goods from GB to Northern Ireland. You can register as a trusted trader. You can declare that the goods that you're transporting are not at risk of being further moved into the EU after they've arrived in Northern Ireland. And if that's the case, then there will be no tariffs payable on those goods. If there are goods that are at risk of moving further onward into the EU, then EU tariffs may be payable on those goods, but there is a rebate scheme that businesses can then avail of. And then the trade in goods between Northern Ireland and Ireland or other EU member states is also as you were. There are no tariffs, no customs controls, no forms to be filled in. And it's one of the reasons that some people have described Northern Ireland as now having an advantage over the rest of the UK in that it can move goods freely from Northern Ireland to GB, and it can still move goods freely from Northern Ireland into the EU states. Okay.
Okay. Thank you, Kevin. If we can move to the next slide, please. If I can turn now to the second of the issues I outlined in the introduction, namely the mutual recognition of goods and product marking. On the 17th of November 2020, the government published various policy papers on the United Kingdom Internal Market Bill, including 2 on the market access principle of mutual recognition, concerning, on the first part, general principles and relevant requirements, and secondly, on location of production. And I'll turn to each of these now. If we can move on, please, Charlie. Looking first at the general principles and relevant requirements, mutual recognition, as I say on the slide, is going to underpin the operation of the UK internal market for goods. A good must meet the relevant regulatory requirements in the part of the UK it is produced in or imported into in order to qualify for mutual recognition with EU law, thus allowing the goods to be sold in any other part of the UK without having to meet relevant regulatory requirements in that other part. Regulatory requirements to be disapplied under mutual recognition are known as relevant requirements and generally relate to the good itself, including its characteristics, its presentation, and any accompanying documentation that must be supplied with it, as well as applying to the sale of goods. The mutual recognition principle will apply to a wide range of supply-related activities, such as I say, trial samples and free gifts, or where indeed goods are leased or hired rather than bought. And requirements relating to the manner in which a good can be sold won't typically be relevant requirements. These are instead dealt with by the non-discrimination principle. If we can move on to the next slide. The second paper published by the UK government in November explains the significance of the location of production to mutual recognition. Products that comply with relevant requirements at the location of their production can be sold throughout the UK to ensure that local producers are subject to their local requirements. The government's bill defines, quote, produced in, unquote, as the place where the most recent significant production step, which is a regulated step, has occurred. So a production step must be significant in terms of the character of the goods or their purpose in order to qualify. So a step would be a regulated step if it would be subject to regulation in the part of the UK where it's being produced, or alternatively, it's a step that means that goods cannot be sold in that part of the UK as they would otherwise contravene regulation in that part. Next slide, please. The next related issue that's very, very important to the construction industry in the context of mutual recognitions of goods and product marking is indeed product marking, because some goods cannot currently be sold in the EU and UK market, as you all know, unless they conform with EU product safety standards and are CE marked. A CE mark is an administrative marking that indicates conformity with health, safety and other environmental protection standards for products sold within the EU. This covers a huge range of product types. The question arises as to whether or not these products can still be imported and exported between the EU and UK as they were previously. And so to answer that question, we need to look to the withdrawal agreement to find out what happens now. And any product that's already been manufactured and is already the subject of a supply agreement for the EU or UK markets can continue to be made available on those markets this currently under the existing CE mark rules, and can even continue to be transported between the two markets post-Brexit until reaching the end customer. However, the fact that a particular product type was CE marked before Brexit isn't sufficient. The particular product needs already to have been manufactured and sold to qualify, although it needn't have actually left the manufacturer's warehouse before the 1st of January this year. So businesses wanting to rely on this rule will need to keep documentary evidence that the goods had already been manufactured and sold before the 1st of January. And from the 1st of January, the rules are changing, although not all of them straight away. And the Construction Leadership Council, which some of you know has taken a very proactive role, not just in Brexit, but also in connection with the COVID pandemic, has published guidance on the conformity marking of construction products for placing on the Great Britain, Northern Ireland and EU markets. So from the 1st of January, as the slide outlines, there are now 3 different product marks that manufacturers and others in the supply chain may need to apply. And the rules governing these marks will depend on where the product is intended to be used. And Kevin, you can comment separately on the regimes as they'll apply in Northern Ireland. But CE mark goods can still be imported into the UK under existing CE mark rules for the remainder of this year. And will in most cases only have to comply with the new UK CA mark rules from the 1st of January 2022. Kevin, would you like to say something about the Northern Ireland market and Mark?
Yes, again, because of the treatment, the separate treatment of Northern Ireland, and the fact that under the protocol it remains a part of the single market for goods, Northern Ireland will have its own mark. As David has pointed out, it's called the UK brackets NI brackets mark. And this year, from January to December 2021, products that are placed in Northern Ireland from GB must at least have the UK NI mark. They may also have the CE mark, but goods placed in Northern Ireland will not conform if they only have the UK CA mark. It might be worth just moving to the next slide, David, just because it's quite useful to see the matrix as to how this operates. I appreciate it's complicated, but this is the first 12 months of the new system, January to December 2021, and along the top we have the place of manufacture, Great Britain first, then Northern Ireland, and then EU, and down the side we have then where the product is actually placed, and you'll see that in the first box, manufactured in Great Britain and placed in Great Britain, you can have the UKCA and the CE mark, but underneath that, if it's manufactured in Great Britain and placed in Northern Ireland, it must have the UK NI mark. Just back to you, David.
Well, and if we can move to the next slide, Kevin, if you'd like to also, there's a summary of the position as from 2022 onwards.
Yes, and the key point, I know we can't have the two slides next to each other, but the key change in this is actually that first box in the top left-hand corner, manufactured in Great Britain and placed in Great Britain. At the moment, in the first 12 months, as we saw, you can have either the UKCA mark or the CE mark. From January 22 onward, you will no longer be able to have the CE mark from products manufactured in Great Britain and placed in Great Britain. You must then only use the UKCA mark.
Yeah, thank you very much for taking us through that summary, Kevin. And if we can move to the next slide, Charlie. I'd then now like to look at the role of notified bodies in the context of mutual recognition of goods and product marking. Notified bodies, which are currently authorised to assess products conformity with a CPR, has now been taken over in the UK by approved bodies. Notified bodies based in the UK at the 1st of January automatically became approved bodies, and new approved bodies can be authorised from this year onwards. New products assessed by a UK approved body will have to be marked with the UK mark to indicate compliance with UK designated standards, in much the same way that products currently have to have a CE mark. EU products with a CE mark will still be able to be placed on the UK market without the need for further testing or additional UK marking. This approach is designed to minimise any disruption to the availability of goods from the EU. The policy intention is that this option is only going to be available for a limited period, however, the duration not having yet been decided. And so it's possible that all products used in the UK will ultimately have to have a UK mark, though the government has said that businesses will be given sufficient notice in advance of the limited period ending. Where manufacturers can self-declare conformity with a standard, they will, during this initial limited period, be free to choose using the existing CE mark, the new UK mark, or both. While EU and UK standards may remain aligned for some time, and as we've said, there's going to be at least this initial remainder of this year while CE marking will be sufficient for products to be sold and used in the UK. Both manufacturers and users of construction products need to understand the changes being made to the rules as they're going to apply in the UK. And where a product has to be conformity assessed by an independent notified body or approved body, an existing report from a UK notified body will no longer be valid for the EU market. Those products will either need to be retested by an EU notified body or an arrangement put in place to have the test reports transferred to and accepted by that EU notified body. Moving on then to the next slide, please. A key further issue that Brexit is going to have in terms of impact on the industry is on the movement and cost of materials. Brexit, and we're already seeing this, is having and going to have a very significant effect on the trade of goods between the UK and the EU. And if your project or business relies on goods imported from the EU, whether by you directly or through your supply chain, then you're going to need to take action to ensure that that supply isn't disrupted or is kept to any disruption is kept to an absolute minimum. So from the 1st of January, an economic operations registration identification number, EORI, as I've said on the slide, is needed to move goods between the UK and the EU. This is a unique ID code to track and register customs information in the EU, and any business importing and exporting goods to and from the EU needs one. Businesses can obtain an EORI number from HMRC. Whilst the trade deal avoids need for additional tariffs, which would otherwise make imports to the UK more expensive, it doesn't do away, as I outlined in the introduction, with friction at the border. With the UK out of the single market and the customs union, physical inspection of goods for conformity with product safety standards and additional paperwork, such as custom declarations, are still required at the border, regardless of the free trade agreement. This is, as we're now seeing, leading to delays and possible non-availability of goods and materials. And UK businesses and EU exporters will have to factor these additional delays and possible cost increases into their programme and price negotiations. I've asked a rhetorical question on the slide as to what the different industry standard forms provide. Primarily, of course, the JCT or NEC suite of contracts. And the answer is that the contracts do provide subcontractors with some protections, but the extent of protection varies significantly dependent upon the contractor and related clauses. So, for example, under the NEC suite of contracts, there's a wide change of law clause, which, if incorporated into the contract, is probably sufficient to provide protection to the project and the contracting entities. In the JCT suite, which most of you will be familiar with, no doubt, the change in law provisions tend to be drafted so that they only apply to legislative changes which have an impact on the physical design and construction of the works, and not therefore due to changes in law relevant to the supply of the products. So the question then arises as to who's liable for the risk of increased materials costs or project delays. If the contract's silent on risk allocation and it's not addressed in project negotiation, then ultimately it's most likely to be the contractor and the supply chain, therefore, who must cover these delays or be hit with possible delay damages. We in the Hill Dickinson construction team are increasingly being asked by developers, contractors and specialist subcontractors to draft Brexit clauses that seek to apportion the risk and give some protection for delays and additional costs arising from Brexit. And this is likely to continue whilst all the ramifications of Brexit are worked through. If they're included in a contract, then it's essential that the important implications are understood and priced into the job as needed. If as a result of any tariff increases, that this can be addressed through JCT fluctuation schedules, which historically haven't been incorporated into contracts, but again, we're seeing that happen more and more now to allow you as the contractors and supply chain to recover increased levies, taxes and costs which may be imposed. Away from the JCT suite and turning to the NEC suite, the new engineering contract, these provide for price adjustments for inflation through a secondary option clause, and the drafting and practical operation of fluctuation schedules and inflation adjustment mechanisms is going to require detailed consideration, because it's been a very long time since the industry's had to deal with the impact of major and sudden changes to prices, the likes of which we could now see. Moving to the next slide, please. Kevin, can I ask you to speak to this slide on the protocol?
Yes, some of this we've already discussed. The protocol has become something of a political issue here in Northern Ireland in the last, well, since the 1st of January, since it came into being. The fact of having checks on goods travelling from one part of the UK to another has upset a number of people here who refer to the border in the Irish Sea. And then we, of course, we had the situation where the EU Commission, with a concern that supplies of vaccines were being routed potentially from the Republic of Ireland into the UK through Northern Ireland, the European Commission threatened to invoke what's known as Article 16 of the protocol, which is a mechanism by which one party to the protocol, either the UK or the EU, can try to suspend the operation of the protocol in extreme situations. A huge controversy blew up around that, and within about 3 hours, the Commission had announced that it was not going to invoke Article 16. And since then, in fact, in the last few days, a statement from both the UK and the European Commission has confirmed that, according to both parties, the protocol will continue to operate and they will find ways to make it work. So it's certainly met with some political opposition from some parties here in Northern Ireland, but as far as we can see for the foreseeable future, the two big players, who are the UK government and the EU Commission, are both committed to the protocol. So as we've said, it affects the goods travelling from GB to Northern Ireland. The Northern Ireland also, as well as being part of the single market for goods, not services, it needs to be remembered, this is all to do with goods. Northern Ireland remains part of the EU's IT systems and will be subject to EU law on VAT. So the VAT rules continue to apply. The Irish Revenue Commissioners in the Republic of Ireland have confirmed that the supply and movement of goods between Northern Ireland and the Republic of Ireland in either direction is unchanged in relation to VAT, and the UK is responsible for implementing those rules. And another quite a contentious point in terms of the continued role of the European Court of Justice, which played out a lot during the Brexit debate. The ECJ will have jurisdiction to enforce EU rules insofar as they relate to Northern Ireland. And UK bodies will be acting as the agent of the EU in enforcing some of the EU rules that apply in Northern Ireland.
Thank you, Kevin. If we can move to the next slide. I just then wanted to focus on what businesses can be looking to do to minimise the possible negative impacts of Brexit in the context of importing goods from the EU. Well, if you're importing goods from the EU, clearly you should be speaking with your EU partners to check what arrangements they've put in place from the 1st of January onwards. As I say, there's going to be additional checks and paperwork involved at the UK borders. Forward planning is going to be needed to manage the new customs process and to make sure no unnecessary delays are caused, for example, by the incorrect filing of incorrectly completed paperwork. Equally, if you're buying through UK wholesalers, ask the same questions of them. Check that they've put the processes in place with their EU suppliers to mitigate the effects of Brexit. You may also find that wholesalers are prepared to negotiate advanced terms for your business to receive preferential supplies of goods if UK stocks were to run low, for example. Equally, if goods that you need for your projects are also manufactured in the UK as well as the EU, then investigate sourcing them locally. UK suppliers will face additional tariffs and customs requirements exporting to their EU customers, and so may well prefer increasing their UK customer base instead as a result. You then also should be reviewing your contractual terms with your EU suppliers. Make sure that you're covered in the event that their product turns out either to be unsafe or doesn't meet with the new regulations or requirements. UK businesses exporting to the EU should also check whether products need further conformity testing, as I outlined it at the outset, or whether or not those test documents should be transferred to an EU notified body to be sold in the EU. Firms should urgently review supplier contracts and look at the question of delays, damages, and mitigation of risk. But I think ultimately, you should be looking to identify and understand the possible effects that Brexit-related events have on existing contractual rights. It's unlikely that those events will have been anticipated when contracts were drawn up during certainly before last year, what the obligations and remedies are, including any consequential impact on timing, performance and enforcement. And in the context of enforcement, I thought I ought to just mention a brief word on dispute resolution, which you'll be glad to know is very much less likely to be significantly affected. Many of you will know that adjudication is the first and foremost means of dispute resolution within the construction industry, and that as a dispute resolution process will continue as normal. Court disputes will continue to be governed by the jurisdiction and choice of law clauses in the underlying contracts. And indeed, I can just update you on a case that I was involved in last week that went to the Technology and Construction Court here in England and Wales, where my specialist subcontractor client Motorcus Construction was carrying out fit-out works to a prestigious London hotel, and they entered into a subcontract with Paolo Castelli, an Italian contractor, and the contract had an Italian law provision and was subject to final dispute resolution process in the courts in Paris, France. And we were not paid monies due, so we commenced an adjudication against Paolo Castelli to recover the monies claimed, and did so, but Paolo Castelli refused to pay, saying this is subject to Italian law and provision for the courts in France. You cannot enforce in the UK, you must go to Paris, France to enforce. And last week the High Court rejected that argument and allowed us to enforce the adjudicator's award, relying on Article 7 of the Hague Convention, which makes clear that enforcement of adjudication award is an interim measure and so therefore allowable. And that is good news, because of course it reinforces the primacy of adjudication as a dispute resolution process and freeing up payment down the supply chain, which of course is what adjudication was always intended to achieve. And so even if there are foreign jurisdiction clauses, choices of law, if you're carrying out construction works in the UK, you should still be able to utilise and enforce adjudication as a means of recovering monies or other entitlements due to you. And if you want the case separately, my contact details are at the end of the slides, and I'll be happy to provide that to you. Moving on, please, to the next slide. Ultimately, parties, as I say, need to understand and identify the possibility of effects of Brexit. Performance may become more difficult inherently under a contract, and therefore more time required for performance, in turn driving up costs. Look at the question of timing of contracts. What's the commitment to timing and delivery? If delivery is late, what are the consequences under the contract? What about exposure to damages, claims for late delivery? Does the contract include a provision limiting or excluding liability in certain circumstances? Do you want to build that in? What rights are there to terminate the contract or engagement under it, where materials are not supplied by due delivery dates or within specified delivery windows, for example? What are the potential exposures for damages for losses incurred? And this can include the cost of procuring and sourcing replacement materials. And mitigation. Parties need to work together to identify and seek to mitigate and reduce the impact of any losses that might arise, to minimize exposure. What early warning systems are in place for suppliers to notify the contractor of potential delays as soon as it becomes likely, and what steps can be taken to mitigate the effect of those delays. So those issues in the context of contracts need very closely to be reviewed, and make sure that you align your contracts up the line with main contractors with terms that you might agree with your supply chain. Next slide, please. I then finally wanted to look at the question of workforce shortages and impact on the UK construction industry, because as you'll all know, freedom of movement for workers has been one of the most contentious aspects of Brexit and is arguably the most important for the construction sector. Across the whole of the UK last year, EU nationals accounted for 10% of all workers in the UK's construction industry, although this percentage rose to nearly 40% in London and the South East. And research very recently published last month by the Migration Observatory at the University of Oxford found that the construction sector has already lost 46% of its skilled EU workers. And this is clearly going to have a massive impact. The Construction Products Association has likewise found that the EU workforce in the third quarter of last year dropped by 28% over a 12-month period. And that number far exceeds the 7% drop in total construction employment across the sector. Leeds, the big surveying firm, have published a separate survey highlighting concern amongst respondents, 75% of whom believe there's a shortage of labour in the UK, worsening shortages and higher construction costs resulting as a result. So I think there's going to be very, very considerable impact moving forward. And freedom of movement ended on the 1st of January. Anyone after this date wishing to work in the UK from the EU will be subject to a points-based application system. And this is designed to attract skilled workers with skill level thresholds of A-level equivalent or above. And EU workers will need to earn points by speaking English, having a salary of at least £25,600 and confirmation of a skilled job to go to. EU workers can also come to the UK if their roles are on the government's shortage occupation list, but that list, however, doesn't include many construction jobs, such as general labourers and plant operators. Trades such as bricklayers or carpenters, QSs, engineers, architects are all covered, but not more manual operators, and that of course is very important. There are obvious implications for the construction industry, as the majority of the labour force don't necessarily attract salaries at the required threshold. And even if the criteria are met, the ongoing sponsorship costs to businesses to bring workers to the UK could well be prohibitive. Notably, whilst visas will not be required for most business travel across the EU for short stays of up to 90 days in any 180-day period, work visas will be required for to work for a longer period of time. Next slide. A common amendment to the JCT suite of contracts that we see regularly in place clarifies that a mere shortage of labour won't in itself constitute a relevant event, an event that gives rise to additional time and money. Contractors working under a contract with this wording therefore need to note that they won't get time or money if visa issues lead in turn to staffing issues and shortage of resource on site. And on a tight programme, even delays of a few weeks while visa issues are resolved could be extremely costly. It goes without saying. So unfortunately, we're seeing labour and skill shortages already giving rise to contract delays, which are ending up in adjudication. So for example, I know of one adjudication involving a road contract approximately 50 miles from the Hinkley Point nuclear facility, which is of course undergoing significant reconstruction. And the contractor on the nearby road project was late completing because it couldn't get labour, as Hinkley Point project was sucking up all the skilled civil engineering labour in the region and paying better than the local contractor could afford. And the adjudicator found that the contractor was liable for the delay damages caused as a result of the shortage of the labour on the road project. And in addition to these programming implications, a shortage of labour could well lead to wage inflation, which again would ordinarily be a cost borne by the contractor and the supply chain. I think that comes to the end of Kevin and my presentation. If we could now move to Q&A and any questions that anyone may have, I'd be delighted to try and answer you as best as possible.
Great, thank you very much, David. Very detailed, necessarily so. You said you're being asked about draft amendments to JCT contracts to reflect the risk of Brexit delays or additional costs. How do these typically work?
Well, there's the issue about whether or not a contractor and the supply chain, specialist subcontractors, can recover additional time and money for Brexit delays. And one has to take the base date as a start point under the contract. Clearly, contractors and the supply chain should be negotiating contract sums and programs to take account of known factors moving forward. But to the extent that there is always going to be an unforeseeable possible event, the negotiations on the contracts need to look at whether or not main contractors, and through the main contractors, the ultimate end client and employer, will agree additional relevant events around Brexit and shortages of labour, say, as giving rise to a relevant event that will allow for additional time and money, and indeed whether or not loss and expense can be covered as a result. So what I'm seeing from this side of the table, David, when it comes to the negotiations, much indeed as we saw with and are continuing to see with the COVID pandemic, is that clients are willing to enter into contract amendments to allow for recovery of additional time for Brexit, so that can be catered for in programs, but not necessarily for additional loss and expense. So that's how I'm seeing the discussions typically flowing at the moment.
It's quite often difficult to decide whether this is Brexit or COVID. So the CBI have termed this scene Brovid. Steel prices, copper prices being, sure, I guess, an example, but also we've seen some price inflation through additional handling charges, tariffs, just flip around money, just a bit of, how does a contractor make sure that they don't get caught out from that, say at tender stage? Is there something they should put in their tenders around fluctuating prices?
Yes, and many indeed are, and making allowances for it, and saying also in their tenders that for so-called Brovid events, David, that they will require additional time to be allowed in the event of unanticipated delays being caused that weren't catered in whatever contract program and price they are able to negotiate at the outset, so that they lay down a marker. The problem, especially with Brovid events, is that JCT does incorporate force majeure as a relevant event, but it doesn't define force majeure. And so there's no legal authority of particular help, whether or not COVID or Brexit would constitute a force majeure event, giving rise to an express entitlement to an extension of time and money. So it's always best to ensure there's no ambiguity on the point by incorporating these as specific negotiation and resultant amendments.
Okay, thank you. I've got one for you, Kevin, now. How do we determine UK origin when exporting our products to Ireland? Our products are made by us, but the copper, steel, aluminium, while purchased in the UK, presumably come from elsewhere in the world. Is there an accepted way of documenting, evidencing the disclosure of the export paperwork?
Well, some of this is what David referred to as the last significant production part of the process. So if there's a substantial production carried out in the UK, then it's more likely that the end product will be designated as originating in the UK. So each case will be on its own merits. If you're talking about raw materials and a manufacturing process, then it seems to be you could certainly declare that to be a product of the UK in many of the cases. It really then depends upon whether you're shipping the goods directly to the Republic of Ireland or if they're going into Northern Ireland with a view to then being transported across the border. There's different paperwork involved, as we've mentioned already, between GB and the Republic of Ireland. It's as if it was going from GB to France or GB to Germany, but from GB to Northern Ireland, it depends then whether or not the good is making its way across the border within Ireland.
Thank you. What can I add to my contract to protect me from delays due to longer lead times for goods being imported? So to add a bit of context to this, I think it's specialist items that are the issue. So if you're buying a lorry load of something, that's something that comes on a pallet, that can be subject to quite long delays. How can you, unanticipated delays, how can you protect yourself from that?
Yeah, well, I understand, and I think that goes back, David, to the initial question you asked me about needing to ensure that any delays, specifically for those reasons, are allowed as a contractual right and give rise to a relevant event, giving so allowing a contractor and specialist to recover an extension of time. The standard form contracts, if unamended, will not allow that. So if you, as specialist subcontractors, are being asked to enter into, say, JTT subcontracts, you need to make sure that you are negotiating and agreeing amendments to the contracts to allow for this. The main contractors, in my experience, are negotiating similar terms with their clients, so there shouldn't be too much pushback. And it's only fair and reasonable that you are able to negotiate proper and adequate commercial protection. And as I say, in the first 2 months of this year, we've already seen the impact it's having on some supply into the UK, with delays of a few days up to a week already. So you as specialists have good grounds for negotiating this and being upfront with contractors.
What about, you talked about labour shortages causing delays. It's less of a problem in our sector, but it impacts our sector when, for example, the dry liner can't progress at the rate that they're supposed to because the EU labour they were relying upon is no longer there. What should a specialist do in those cases where they are delayed by other trades?
Well, if you're delayed by other trades, then in those circumstances, David, that should give rise to an automatic right to an extension of time under the JCT, because the employer who's engaging the other trades, assuming that we as specialists aren't ourselves engaging those other trades, so where the other trades are engaged by the main contractor and they cause delay to us as specialists, then as a matter of right, we should be entitled to time and money because the delays are acts of prevention for which we're not responsible under the subcontract.
Are there any pending agreements between the UK and the EU that might impact us? Seem to be in a permanent state of negotiation.
Yes, I'm not aware. I mean, as you say, David, there are many agreements currently being negotiated. I'm not aware of the outcome of or likely outcome of those negotiations or any new agreements that are about to be published. Kevin, are you aware of anything? I mean, of course, the protocol will be updated soon.
The protocol, yes, there's a transition period, another transition period. It's a 3-month transition period till the end of March, particularly for agri-food products, and the further checks and controls will be introduced from the 1st of April. And that has actually had, some of our clients have actually told us that they're starting to source more goods from the Republic of Ireland because they're easier to source and there are no checks and controls across the border on the island of Ireland. So some of the supermarkets here who have been finding, even during the transition period, finding it difficult to get a ready transport without any delays. Obviously, these are perishable goods in a lot of the cases, and you can't afford even 1 day's delay. So they've actually turned to suppliers in the Republic of Ireland in a number of cases, and that may then become the norm for them, and they may go back to sourcing some, but not all of the products in GB.
But you're not aware of any impending further legislative changes?
No, and as I mentioned, both the European Commission and the UK government endorsed their existing commitment to the arrangements that apply here only in the last few days, despite the controversy and the opposition that there has been. So I don't see there may be some tinkering at the mechanics, but not any substantive amendment to the documentation. Okay,
well, I'm afraid our time is up. Thank you both very much for that really detailed and informed briefing. The slides will be available for anyone in your teams who would like to have a look at these. But in the meantime, David and Kevin, thank you very much indeed. And don't forget, if you're a BESA member, come back to our team who will be able to answer your questions. But in the meantime, thank you very much, Kevin and David.
Thank you.
Thank you, David and Charlie. Thank you both.
Thanks. So coming up next Tuesday, 9th of March, we are hosting a SHEP, Safety and Health and Engineering Partnership webinar again, this time on welding, fume and metalworking fluids. So they're always popular. Book early for that. Otherwise, hope you have a good afternoon, and we will see you again shortly. Thank you.